Greetings, everybody. It's Magenta, and it seems my lovely dame has made another video addressing Big Boss Calvin, who is a TFL member, True Force Loneliness, and a believer in the New World Order, and so a fighter against the quote New World Order. Now, in her video, she has requested again to Calvin that she wants him to remove the video on another site where he reveals her personal information. Calvin, it does not matter that her information was on another website. It does not matter that this is, quote, the internet. What you did morally was wrong and possibly legally wrong. You did not have her permission to reveal her information. Now, as to your threats to her, or as you call them, promises, they are legally wrong. You can go to jail for them. They can fall under harassment or stalking, and a threat made by any means, be it telephone, written, and the laws have caught up with the technology, electronic, which means email, private messages, IMs, video format, video sharing site, any of that. It is illegal, and your victim can take action against you in a court of law. She is asking you very nicely, remove the video, and she will not pursue legal recourse. You have to remove the video and leave her alone. She asks you to leave me alone and Christine alone and to apologize to us. I'm going to say apologize to Christine. I could care less if you apologize to me, because you're not a threat to me. You're of no threat or harm to me. I know how to defend myself, and I have family and friends with me pretty much all the time. But that's neither here nor there. Let's get into, for a moment, Calvin, the legality of your harassing dame, my lovely dame. And mind you, no, you cannot reverse this on us, because we did cease and desist on bothering you. You said stop making videos about me, stop talking about me, and we did. We complied. You brought this back, and you're the one that kept sending death threats and harassing PMs on YouTube. So I want to bring to your attention the legal statute in the state of Dame's, where Dame lives, in her state, because you would be subject to the jurisdiction of your victim. And they have a law on the books. I should say not a law, but an act on the book for harassment. Criminal Offenses, Harassing and Obscene Communications Act. Section 1. Any person in this state who sends messages or uses language or terms which are obscene, lewd, or immoral with the intent to offend by means of or while using a telephone, telegraph facilities, equipment, or wires of any person, firm, or corporation engaged in the transmission of news or messages between states or within the state of Illinois is guilty of a Class B misdemeanor. The use of language or terms which are obscene, lewd, or immoral is prima facie evidence of the intent to offend. Now, granted, that relates to people within the state of Illinois, but it also covers, briefly, if you listen, across state lines. You are across state lines, so technically you also could be under federal jurisdiction. Nobody quote me on that. Section 1-1, harassment by telephone. Harassment by telephone is the use of communication with any of the following purposes. 1. Making any comment, request, suggestion, proposal, which is obscene, lewd, lascivious, filthy, or indecent with an intent to offend. 2. Making a telephone call, whether or not conversation ensues, with the intent to abuse, threaten, harass any person at the called number. 3. Making or causing the telephone of another repeatedly to ring with the intent to harass any person at the called number. 4. Making repeated telephone calls during which conversation ensues solely to harass any person at the called number. 4-1. Making a telephone call or knowingly inducing a person to make a telephone call for the purpose of harassment any person who is under the age of 13, regardless of whether the person under the age of 13 consents to the harassment, if the defendant is at least 16 of age at the time of the commission of the offense. 5. Knowingly permitting any telephone under one's control to be used for any of the purposes mentioned herein. Every telephone directory published for distribution to members of the general public shall contain a notice setting forth a summary of the provisions in this section, blah, 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 blah. Now that's telephone communications. Here we go into harassment via electronic communications. Section 1-2, harassment through electronic communications. A. Harassment through electronic communications is the use of electronic communication for any of the following purposes. 1. Making any comment, request, suggestion, proposal, which is obscene with an intent to offend. 2. Interrupting with the intent to harass the telephone service of the electronic communication service of any person. Of course, we have now broadband and cable. 3. Transmitting to any person with the intent to harass, and regardless of whether the communication is read in its entirety or at all, any file, document, or other communication which prevents that person from using his or her telephone service or electronic communication device. 3-1. Transmitting any electronic communication or knowingly inducing a person to transmit an electronic communication for the purpose of harassing another person who is under the age of 13, regardless of whether the person under age 13 consents to the harassment. The defendant is at least 16 years of age at the time of the offense. 4. Threatening injury to the person or to the property of the person to whom an electronic communication is directed, or to any of his or her family or household members. 5. Knowingly permitting any electronic communication device to be used for any of the purposes mentioned in this section. B-1. Electronic communication means any transfer of signs, signals, writing, images, sound, data, or intelligence of any nature transmitted in whole or in part by a wire, radio, electromagnetic, photoelectronic, or photo-optical system. Electronic communications includes transmission by a computer through the internet to another computer. 2. Family or household member, including spouses, former spouses, parents, children, stepchildren, and other persons related by blood or by present or prior marriage. Persons who share or formerly shared a common dwelling. Persons who have or allegedly shared a blood relationship through a child. Persons who have had a dating or engagement relationship. Persons with disabilities, their personal assistants. For purposes of this act, neither a casual acquaintanceship nor ordinary fraternization between two individuals in a business or social context shall be deemed to constitute a dating relationship. C. Telecommunications carriers, commercial mobile services providers, and providers of information services, including but not limited to internet service providers, hosting service providers, are not liable under this section, except for willful and wanton misconduct by virtue of the transmission, storage, caching, or electronic communications or messages of others, or by virtue of the provision of other related telecommunications, commercial mobile services, or information services used by others in violation of this section. Basically, Calvin, she can not only sue you, she can sue the websites that you're posting this information on if they do not remove it when she requests. But see, that's not where it ends. In turn, the company that you put the videos on can turn around and sue you for losses and damages because you put up a video that put them subject to being sued. And, yeah, I hate to break it to you, Calvin. Everything I just read to you is pretty much tied and true in pretty much all the states now. Which means the state of your residence would have actually very similar laws on the books. Translation: you are in a shitload of trouble if this goes to court. Remove the fucking video!